When it comes to New York State criminal matters, you cannot take a plea before seeing your discovery. Now, you may be tempted to jump on the one-time offer from your defense attorney, but you really don't have a good sense of what the case is until after you see what evidence the prosecutor has on you. And what we've recently had happen on a case is, and I'm not going to talk about the specifics, I'm not going to mention the county that this happened with or what the charges were, but we recently had a client get his discovery, and we're going through the discovery with the client, and a very important piece of evidence in the case was the cell phone. And so we get a voucher from the NYPD that lists the property, and the client's looking at it, and the client tells us, this is not my phone. The make and model that they have on the voucher is not my phone. And so with that information, we never went to the DA's office to say, hey, what happened to the phone? But we knew they did not have the correct phone if the voucher was correct. And we were able to work out an insane plea. The plea was so good, the judge had all sorts of questions for us when we were taking it because the judge was concerned that the plea was too low. The reason why we got the plea, and it's the plea that we've asked for, is because they lost a very important piece of evidence and they were not going to come clean to us about it. But that is why they had to cut their losses. We did not take a plea early until we saw what they had. And in looking at the paperwork, they did not have the phone. They did not have this critical piece of evidence. And that's what got us a phenomenal plea. So low, I wish I could brag about it, but I have to keep getting good results for other clients. With that said, don't ever take a plea, generally speaking, on your criminal case in state court until you get your discovery and you go through it with your attorney.